the earlier valuation. That has to be addressed also.
Why? If it is there in your representation,
It is the representation.
it will be there, nothing. I will not add anything.
To be stated in the order. That is added.
What? Affidavit of service affidavit of service দিয়েছে তো? ঠিক আছে।
We wanted to amend the cost cycle. Much of Lordship, please, Your Lordship. Tenants in respect of the property.
1 minute, let me understand. You are for the petitioner.
Yes.
Corporation.
Private respondent. Lordship, the petitioners herein are tenants in respect of a property which the private respondent claims to be a dilapidated building. Now, twice notices were issued under section 412A. They were scrapped. They were withdrawn, not effectively, but fresh notice were given. We not withdrawn by any further notice, but fresh section 412 notice given. Hearing given. In the hearing, the officer comes to a finding that there was a notice issued under section 411. No compliance has been made. Hello,
No?
Compliance of the 411 notice has been
Compliance.
made. Yes. Your Lordship knows that 411, the municipal commissioner has to come to a finding that the building is in a ruinous state and it has to be demolished. And the opportunity of hearing has to be given to the occupier and the owners of the properties that whether they want to demolish the building or not. Your Lordship, that is the first non-compliance that there has been violation of 411 because no notice has been served upon the occupier. Now, without serving any notice, this 412 proceedings has been conducted.
According to you, the building is in a habitable position.
Your Lordship, it is not in a position which has to be demolished, according to
Alright.
me. Yes. Anyways, whatever the proceedings they are continuing with, in the order they refers that 411 notice has been given. No 411 notice has been given. I will be happy if they can show that 411 notice has been served upon the occupier. Because without the 411 compliance, the 412A proceedings cannot be initiated. Because the municipal commissioner, after hearing the occupier, has to come to a finding that the building is a ruinous state and it has to be demolished. That has not been complied with. Now, 412 order passed. Hearing was given. In the order, the officer comes to a finding, authority comes to a finding that they have to be vacated, building has to be demolished. And Lordship, the second grievance is that Your Lordship knows that there is a circular issued that if a dilapidated building has to demolish and if there are existing tenants, what compliances has to be made. That circular has not been followed. There is
Which
no
provision has not been followed of the circular?
Yes, Your Lordship, I am coming to the circular. Your Lordship will kindly come at page 65.
Yes.
If Your Lordship takes from point number 8.
8.
This is the circular, Your Lordship, 2021. The following procedures to be adopted for extremely dilapidated building which are occupied by the occupiers tenants to be taken under 412A. The concerned executive officer of the building department should invariably inspect the building suffering from and decaying to take stock of the occupiers of the premises. Now, this stock of the occupiers of the premises has not been taken, first.
Alright.
Second, the quantum of the premises occupied by each of the occupiers thereat with corroborative documentary evidence including legal inquiry showing possession of the premises by the occupant should be ascertained. Not done. Third, this should be sent to the concerned assessor collector for initiating proceeding of recording this in the IB after giving a reasonable opportunity to all concerned including recorded owner. If it is found that the occupants of the premises are rightful occupier in terms of law, certificate of possession, extract of IB to be given to every occupier. So not done. No certificate of possession given, but admittedly we are tenants. That I will show. Issued by the assessor collector. 4. DEC building is authorized to necessary section. I am not going into that because this has been invited. No notices were given. 5. Reconstruction of the development plan should provide for at least 24 months temporary rehabilitation in rent lieu for the period of reconstruction. This has not been done. So they have to give a earmark space as to where we will be rehabilitated after the building is reconstructed and a 24 months rehabilitation plan. Not done. Once the building is completed, the promoter occupier who undertake the construction should give correspondent share held by the occupiers before the demolition of the dangerous building and no CC shall be given under the same is not done. We are not aware whether this has been done or not. No earmark space in the plan submitted. If such plan is not forthcoming, then the building has to be demolished. So these steps has not been followed, Your Lordship. In fact, they have admitted in one of their notices that once the building is reconstructed, where the admitted tenants, they will give us the space. Earmark has been made. That is in one of their letter that they have stated. But we are not aware whether any proposed plan has been submitted or not, whether this rehabilitation program is there or not for 24 months.
Very well, let me hear.
Yes. There's only one thing I will just like to clear it out before you say anything. Earlier, a writ petition was filed. Now, writ petition was filed challenging this order, by which 412 order, but that writ petition was dismissed for default. But what happened? There is a separate cause of action regarding the non-compliance of this circular which we are challenging. And the earlier writ petition, some of them are not parties. This writ petition has been filed by some of the